Court calls case People versus Courtney Waldick.
What you're about to hear is not just a routine bond hearing. This is the moment where a case changes direction. A woman lies dead on the side of a road. A driver goes home. No 911 call, no immediate help. And now, months later, the court is being asked a brutal question. Was this a tragic accident or a calculated choice? Judge Simpson is about to hear arguments that go straight to the heart of accountability, danger to the public, and whether freedom before trial is still justified. Prosecutors claim new evidence paints a far darker picture than what the court initially knew. Deleted messages, delayed reporting, and actions that may have cost a woman her life. The defense? They argue constitutional rights, compliance, and presumption of innocence. This is where bond stops being about money and becomes about trust. Trust in the defendant, trust in the process, and trust that justice hasn't already slipped through the cracks. So as you watch this unfold, ask yourself early, if you truly believed you hit a person, what would you do next? Because the answer to that question may decide everything.
We are having with Courtney Waldick. Judge, this is date and time set for our second probable cause conference. At this time, if Waldick is inclined to waive her right to preliminary exam, and we've gone over those rights.
Waldick, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, Your Honor.
And you understand that you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor, we do. And if that's the date, I'd like to address bond at the appropriate time.
Pardon?
Yes, I do waive, but in case this affects her pretrial date, I'd like to address bond at the appropriate time.
All right. So before I set the date, you may address bonds. Go ahead.
Your Honor, at the time my office charged this case, we requested a $100,000 cash surety bond. At this time, I am renewing that request.
This is where the temperature in the courtroom rises instantly. Renewing a higher bond isn't routine. It signals that the prosecution believes the original bond no longer protects the public or the integrity of the case. Notice how the prosecutor immediately frames this around new information. That phrase matters. Courts can revisit bond only when circumstances change. And here the state is saying, what we know now is far worse than what we knew then. Bond isn't punishment, it's a risk assessment, flight risk, danger to the community, risk of tampering with evidence. And the prosecution is clearly aiming at all three. When they reference the investigation being substantially grown, they're laying the foundation for why the magistrate's earlier decision may now be outdated. Here's the question for you watching. Should bond be based only on past compliance or on new evidence that reshapes intent and responsibility? Because that debate is about to dominate this entire hearing.
I understand that Ms. Waldick was given a $50,000 10% bond at the time of her arraignment. When we were last before Your Honor, I did not have the benefit of certainly I still don't have the report because the investigation continues to be ongoing. However, the information that is now available to me has grown substantially since we were last here. I will start off by going through essentially the timeline of what occurred here. In the early morning of January 21st, 2024, people that were commuting to work or other locations observed and discovered the body of Miss Shelley Mason lying on the side of Prospect. It was unknown at the time what occurred to Miss Mason, who killed her, and who was involved, but the police were rapidly able to put together an investigation that led to them to be able to identify Miss Waldick.
This is the factual spine of the case, and it's devastating. A body discovered by strangers going to work, not by first responders called to help, not by the driver who caused it. That detail alone creates a powerful emotional and legal undercurrent. From a legal standpoint, identification isn't just about who hit the victim. It's about what happened afterward. Courts look closely at post-incident behavior because it reveals consciousness of guilt. Did the person stop, call, render aid, Or did they leave, delay, and control the narrative later? Emotionally, this moment reframes the entire story. Miss Mason is no longer an abstract name. She's a person whose last moments were spent alone, injured, and unseen. Ask yourself honestly, if help had arrived sooner, would the outcome be different? Because that single possibility weighs heavily on everything Judge Simpson considers next.
As the person that killed Miss Mason. On January 20th, the day of the crash, Miss Waldeck had been to a baby shower. She then went to Lay's in Ypsilanti with her friends, where she was drinking with her friends. She was texting people that were not present, somebody who was either her friend or her boyfriend. She had texted things to her boyfriend about meeting up with him later. In her text messages to her boyfriend, she indicated that she was out drinking with her friends and that she would be continuing to be drinking with her friends. She referenced to him that she wouldn't feel comfortable driving too far to meet him later, and I apologize for my language, but that she was going to be really hopped up. She did drive instead, though.
This section is legally explosive. The prosecution isn't just saying she drank, they're showing awareness. Text messages matter because they capture mindset in real time. Saying, "I don't feel comfortable driving," followed by choosing to drive anyway, can transform negligence into recklessness. From a courtroom perspective, this speaks directly to foreseeability. If you know you're impaired and still get behind the wheel, the law treats your choices far differently than a truly unavoidable accident. The state is subtly building intent without using the word itself. And for jurors and judges, that contrast is powerful. She knew the risk. She acknowledged it. Then she ignored it. Here's the audience question. Does recognizing danger but proceeding anyway make you more responsible or less? Because the answer defines how severe this case truly is.
She drove her car and she killed Miss Mason. After getting home, she didn't stop. She did not call the police, and she left Miss Mason there. After getting home, Miss Waldeck saw her roommate's name was Sarah. Now, notably, we now know that Sarah actually drove that same route as Courtney a couple minutes ahead. And Sarah did see Miss Mason alive and walking on the road. And Sarah initially told the police that she saw Miss Mason walking on the shoulder of the road, which is consistent with physical evidence in this case as well. But when Courtney got home, and this is supported by Sarah's statement, as I understand it, as well as from the text messages that followed this, Courtney was quite hysterical. I'm going to call her Courtney. Courtney told Sarah that she had hit someone and that she needed to go back. Courtney and her roommate took over an hour to return to the scene. During this time, Courtney did not call the police.
An hour. In emergency response time, that's an eternity. This is where the prosecution pivots from accident to moral failure. The law recognizes that immediate aid can save lives, and delays can kill. From Judge Simpson's seat, this delay raises a crucial bond issue: judgment under pressure. If someone freezes, panics, or avoids responsibility in a crisis, courts worry about how they'll behave when facing serious charges. The fact that calls were made to friends and family, but not to emergency services, is devastating optics. It suggests prioritizing self-preservation over human life. Ask yourself, who do you call first when something terrible happens? Help or comfort? Because that instinct tells the court everything it needs to know.
She did not ask for anybody to go out to the scene to help Miss Mason. Instead, she started texting her friends, her family. Her reaction to this was substantial and quite emotional. However, when Courtney came in for her interview with the police, which, mind you, was the Friday following, so she came in for her interview on January 26th. The crash occurred on January 20th. She told the police that she believed that she hit a deer. This deer had just kind of popped out of nowhere, that she saw it just coming at her. We know from our interview with Sarah, the roommate, that Miss Mason was walking down the road. Sarah saw Miss Mason a couple minutes ahead of Courtney and that Miss Mason was walking down the road. But what we also know is that Courtney didn't think she hit a deer. Sarah has now told us that Courtney came home and said, I think I hit someone. Sarah has confirmed for us that there was no mention of a deer. So when Courtney got home thinking that she hit someone without calling the police or stopping to help that someone, she continued to tell her friends and her family what she had done and what stress she was under. She didn't call the police. Leaving Miss Mason lying in the snow on the side of Prospect in who knows what condition. And I will say that the evidence of this case bear out that it is possible that if Courtney had just called the police, Miss Mason might still be alive. That's why we have crimes like this. That's why the penalties for crimes like this are so substantial, because Miss Mason may have still been alive and may still be with us right now. Miss Mason was a mother, she was a daughter, and she was a grandmother. And that woman was left on the side of the road without anybody with any help being sent her way. But not only did Courtney not call the police and not attempt to save Miss Mason in any way, what I now know is that Courtney then deleted approximately 150 messages off of her. She deleted those messages that I referenced earlier about her not wanting to drive so far. She deleted a message about her being fucked up. And I will make clear for the record, the message says, I'm going to be fucked up, not that she currently was when she sent it. She deleted a message that said, I wish I would have called 911 immediately. And she also deleted, got to live with it and get my car fixed ASAP. Were deleted before her phone was turned over to the police. What she also did when she got home, and I know that defense counsel will argue that this was normal for her behavior, was she parked her vehicle in her garage.
This is the moment bond hearings are often decided. Deleting messages isn't accidental, it's intentional. And courts treat it as potential evidence tampering. Whether or not those messages are ultimately admissible, the act of deletion alone signals risk. Parking the damaged vehicle in a closed garage adds another layer. Again, this isn't about guilt, it's about behavior. Judges ask, will this defendant preserve evidence going forward or manage it? Here's the legal truth. Bond can be raised solely on risk of evidence destruction. And this is textbook. Audience question, if you had nothing to hide, would you erase the record? Judge Simpson is absolutely asking that right now.
That car remained in the garage, and the garage door remained closed, as far as I understand it, with the garage inside. The police subsequently did a search warrant, and it wasn't until they were there with the search warrant that they were then given consent to go into the garage and discover the Jeep. Your Honor, her guidelines, as I score them, are 19 months, 38 months, as I currently have them scored. My office requested a $100,000 cash surety bond at the time of charging this, and I am again renewing the request. Thank you, Your Honor.
Response.
Thank you, Judge. Obviously, I don't have to tell the court that Ms. Waldick stands here before you innocent until proven guilty. I'm not going to try the case in front of you, but I will address some of the things that were just said. First and foremost, there was an arraignment on January 28th where, as Ms. Hughes indicated, their office requested a $100,000 bond. A record was made. Prosecutor who attended the Zoom arraignment on that Sunday, myself, each made a record, and bond was set at $50,000, 10% with an alcohol tether. It's our argument to the court that that was not an unreasonable bond, nor was it an abuse of discretion. The fact that there's an ongoing investigation or this was charged early, that's not my client's fault. Maybe the prosecutor's office should have waited until the investigation was complete. With that said, Ms. Hughes indicates there was some drinking going on. My client turned herself in as a person of possible interest to the Washtenaw County Sheriff's Department to Detective Webb on January 26th. That date could have been sooner, and the police report indicates could have been sooner, but Detective Webb actually asked her to come in on Friday and not the Thursday beforehand. I appreciate Ms. Hughes said that no evidence that Ms. Waldick was quote unquote fucked up, but that maybe she had said she was going to be. That talks about something in the future. It doesn't mean that she was. This same witness that Ms. Hughes talks about, and I don't think Ms. Hughes would, this Sarah, quote unquote, Sarah, who has come forth and said some things, is the same Sarah who said she knew nothing about this originally. So now we have two different stories from Sarah, because originally Sarah said she had no idea what happened on the date in question. Ms. Waldick is now, since the arraignment, been before you twice here on February 22nd for her. She's been compliant with bond the whole 2 months to today's date that she has been on bond since being arraigned, with an alcohol tether the whole time before she was released from jail, with absolutely no issues. So this is the second time before you, but including going to the sheriff's department to speak to Detective Webb, she's appeared 3 times. She's not a flight risk. In addition to being on alcohol tether and having no issues, she's also reporting, checking into community corrections weekly. I've heard nothing today regarding any bond violations because I don't think there are any. There's been no change in circumstances as we see it since the date of the arraignment. Ms. Waldick is definitely not a flight risk, and she's not shown that she's a danger to the community in the past 2 months at all. Again, there's been no allegations of that. Judge, the 8th Amendment of the U.S. Constitution indicates that the court shall provide a bail that is not excessive.
This is strong lawyering. The defense is doing exactly what they should, anchoring the argument in constitutional protections. Excessive bail is forbidden and precedent matters. But here's the tension. Constitutional rights don't exist in a vacuum. They're balanced against risk. Compliance so far helps the defendant, but it doesn't erase new evidence. Courts routinely say past behavior matters, but evolving facts matter more. This is the tightrope Judge Simpson must walk. Raise bond too high and it looks punitive. Keep it too low and it looks naive. Viewer question: should clean behavior after arrest outweigh troubling behavior before it? Because that's the heart of this debate.
Stack versus Boyle, 342 U.S. 1, and People versus Edmond, 81 Mishap, 743 says bail that is set in an amount higher than reasonably calculated to give adequate assurance that the accused will appear is excessive under the 8th Amendment. Edmond goes on to say that courts have held that money bail is excessive if it is in an amount greater than reasonably necessary to adequately assure that the accused will appear when her presence is required. Court rules are designed to enforce these principles, Judge, and under these rules, there's a double presumption that a pretrial arrestee will be released without any case bail requirement. And that's stated in 765.6, MCLA 765.6, that in part, a person accused of a criminal offense is entitled to bail. The amount of bail shall not be excessive. Court rules go on to indicate what the money bail should be and what is required, and what's considered in terms of setting bond. And those things under subsection F 6.106 say a defendant's prior criminal record. She has none. Defendant's record of appearance and non-appearance, or flight to avoid prosecution. She's been at everything. She's actually been at more.
Well, that flight issue also includes concealment of evidence, doesn't it?
And I guess this came up at the bench when we were here on, surprisingly, on 2/28 or 2/20, our last probable cause conference date, 2/22, when neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed gainfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
From the people.
Nothing further, Your Honor. Thank you.
The court, in looking at the file, and so that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. There were certain things that came to the court's attention that were not in the magistrate's mind nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could probably be argued before the court. What was not known, certainly to the magistrate at the time, was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprised counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages, which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Further,
This is Judge Simpson drawing a firm line, not emotional, authoritative. Judges do not tolerate insinuations that they're acting improperly, especially regarding warrants and bond review. What you're seeing here is judicial credibility being protected. He makes it clear. He knows this case because it passed through his desk. That matters. It reinforces that his concerns aren't casual, they're informed. This moment shifts momentum. When a judge speaks like this, it often signals that a ruling is coming, and it won't favor the side being corrected. Audience question, when a judge pushes back this hard, do you already sense where this is going?
more there is in terms of the issue of flight, of concealment of evidence and the like. Now the deletion of text messages and other evidence in this case, which have just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant, the offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate, and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from 50,000 cash surety to $100,000 cash surety.
This is the ruling before the ruling. Judge Simpson is laying out his legal justification step by step. Delay, knowledge, deletions, concealment. This is how judges insulate decisions from appeal. He acknowledges compliance. That's fairness. But then he explains why compliance alone isn't enough. Bond is forward-looking. It's about future risk, not past convenience. At this point, the increase is inevitable. The only question is how much. Ask yourself, if this were your family member on that roadside, would this bond feel appropriate?
Are they, counsel, just for the purposes of anything, are they able to do that right now or?
We've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
She'll be taken back and do that. I think they can do that.
Hold on, sorry guys. We need to arraign her on the information. I apologize. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit
And
court.
we'd waive the reading of the complaint and have the matter set for circuit court pretrial. I asked that she'd stand.
She stands. Defendant having waived from a reading standing mute, the court will enter a not guilty plea. Pretrial, technically counsel just, and I'll do it for the convenience of your schedule. Technically, she would be given the end date, but if it looks like you're gonna post, I can give the out date. So
Yeah, she'll be out.
she'll be out.
May 2nd at 1:30 before Slate Thursday.
Pretrial, May 2nd, 2024, 1:30 before, that's a Slay Monday,
Slate Thursday.
Slay Thursday.
Judge, after that surety is posted, can I come back with proof so that, please?
Thank you.
Judge Simpson has spoken, and the message is clear. This court now sees this case differently than it did at arraignment. New evidence reshaped the risk assessment, delayed reporting, deleted messages, actions that may have cost a life. This ruling does not declare guilt, but it does declare concern. Concern about judgment, about accountability, and about whether the original bond truly reflected the gravity of what happened on that road. The broader implication is powerful. Pretrial freedom is conditional on trust, and trust can be lost. Now we want to hear from you. Do you agree with the bond increase? Should it have gone even higher, or stayed the same? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.